So number one, HIPAA and 42 CFR Part 2 prevent me from making any type of report of abuse of a child or abuse of a vulnerable adult. Is that true or false? Number two, I should never tell a patient that I made a report or involve them in the process of making the report of abuse. Examples of elder abuse or abuse of a vulnerable adult can include hitting, neglecting medical needs, physical restraint, and misuse of the person's finances or benefits. Number four, federal laws do not prohibit me from duty to warn as long as I only disclose the information that is absolutely necessary and that is specific to the threat or danger. True or false? Number five, counselors should only report child abuse if they directly witness it or can provide proof of their claim of abuse. Number six, prior to making any report of abuse or duty to warn notification, I should always first speak with my supervisor to ensure I am compliant with the correct procedures and laws. True or false? And feeling conflicted about having to make a mandatory report or upset after witnessing a reportable event means I am not a competent counselor. And then the last question, number eight, how I clinically address a patient's disclosure and behaviors that led to reporting can be affected by different factors such as whether the patient was the victim or perpetrator and whether or not the abuse is still occurring. True or false? And like I said, we will revisit those at the end of the session. So today we're going to be going through the differences between what's a mandatory report versus permissive reporting and going through what duty to warn is and how this relates to what you may need to report and what specific patient information applies or that you're allowed to share. Also going over what your role is in having to make a report, and then how to also maintain that compliance with HIPAA and 42 CFR Part 2 if you do have to report such information or event. We're going to go over some of the different types of abuse and types of populations, including some stats on prevalence of that type of abuse, as well as signs and symptoms of abuse. We've got some different case scenarios for each of the populations and type of abuse, and we're going to go through those. And then also, just to give you guys some things to think about as far as how mandatory reporting or necessary reporting can have a clinical impact on the counselor-patient therapeutic relationship, as well as you personally and for the patient. So what exactly is mandatory reporting and what is my responsibility? So with mandatory reporting, state laws legally compel you to report different types of abuse of children and vulnerable adults. It's often specified in each state to a specific type of profession that has to do the reporting, such as a physician or a counselor or teacher. Some states have declared and are allowed to declare all citizens as mandatory reporters.
Muted. Unmuted.
Sorry. For a second, I think it muted. Sorry. Some states can declare all citizens as mandatory reporters, such as for reporting things like child abuse and neglect. It details to whom you have to make the report, the time frame you have for making the report, and specific information that has to be included. Some states, even if they don't have mandated reporting for certain types of things like something like domestic violence, they may still mandate that you have to take a specific action. So you may not have to notify law enforcement, but you may be required to provide education or referrals for the patient. So with permissive reporting, this is considered more voluntary. You're permitted to make a report, but you're not legally obligated or bound to do so. So states can mandate reporting for certain professions, but then keep it permissive for others. Some states include the caveat that this can only be done with the knowledge and permission of the victim. So you're not mandated to report, and you can do so voluntarily, but you really have to involve the victim and make sure that they're aware and get their permission to make the report. And then federal laws that protect patient protected health information like HIPAA and 42 CFR Part 2 don't explicitly allow disclosure for permissive reporting. And we're going to go through and explain that. So the extent of the knowledge that you have about this potential reportable event can also be defined and impact what exactly you have to do. So extent of the knowledge required to trigger a duty or mandate to report varies by state. Some laws call for reporting upon a mere reasonable cause to believe or reasonable suspicion. Other states require the reporter to more formally know and have a true suspicion or actually observe a reportable event occurring, which obviously is a much higher degree of knowledge. This language and the required content of the report can also vary depending on whether the victim is a child or if it's past abuse and they're an adult now. It could impact it if they were a child when the abuse occurred, or if you're talking about an adult or vulnerable adult. And then the language can vary from state to state in general. So familiarize yourself with your state's laws and keep up to date with any changes. And the reason why we did not include the details of like for every single type of abuse and reporting for each of the states where we have treatment locations is because things can change year to year, and because we wanted to make sure this training and the information was applicable for everyone and could be used later on for newer hires as well, that we wanted the information to be more of a resource and an overall guide, but you are still responsible for finding out, being familiar with your local laws, and if you answer to a licensing board, a lot of the time that requirement is written into their regulations and possibly even into their code of ethics, kind of guiding what you have to report. So first, talking about abuse that is mandatory to report in all states. All states mandate some level of reporting of observed, witnessed, known, suspected, or reasonable cause to believe child abuse, neglect, endangerment, abandonment, and dependency. And then for vulnerable, endangered, incapacitated, elder adult abuse, neglect, and exploitation. And so you'll see elder abuse and vulnerable adult are kind of lumped in together because a lot of the actions you're supposed to take and the types of abuse and so forth are very similar, if not identical, for just a vulnerable adult who's over the age of 18 versus someone who's elderly. But some states do distinctly separate those as well. So just to keep that in mind. So again, what we just talked about was mandatory reporting. So the child abuse and neglect, and then elder or vulnerable adult. And now looking at permissive reporting, this is where it varies a lot more by state. So the requirements vary, and some may be mandated reporting, but others only require that a specific action can be taken, like I mentioned a few minutes ago, of something like providing resources and education to the patient. So examples of permissive reporting are duty to warn. The patient admits to a specific plan to harm a specific person. Domestic violence. Human trafficking, both if the victim is an adult or a child, and then also if this is human trafficking for labor and for sex. Pornography, so mostly applies with child pornography and possession, creation, distribution of it, as well as, I'll give you an example later on of a specific state that has actually added a law making it a mandatory reportable event if a patient reports to you that they've ever viewed child pornography. And then some states even have a requirement that you must report if a patient has died and it is likely, or you know that it is a direct result of, because of some sort of abuse or violence that led to their death, something like domestic violence. You may be required in your state to report that knowledge of the abuse if it seems related to their death. So what about considering these against the requirements we have to comply with 42 CFR Part 2? So the federal law explicitly protects any PHI that would identify a patient as having or having had a substance use disorder, either directly by reference to publicly available information or through verification of such identification by another person. And so, layman's terms, as you know, from the confidentiality of substance use treatment records, training, and handouts that are available to you at any time, that this essentially means, without patient consent or under the handful of allowances without written consent, that the federal law identifies, that not only can we not discuss the patient's treatment, we can't even acknowledge their presence or that we know them and provide any type of information that is related to their substance use treatment. But 42 CFR Part 2 does explicitly allow for individuals that work for a drug treatment program in those agencies to report known or suspected child abuse and neglect as required by their state laws. So you still are required to maintain confidentiality of the patient's substance use disorder records, including if the records are requested for civil or criminal proceedings that may arise out of the report of suspected child abuse and neglect. And so we're going to go through some different case scenarios and give you some more information about that. But essentially what that means is it allows you to make the report. And that example for child abuse is specifically given in the federal law, but you still can't give or provide all of the information about their substance use disorder, their treatment with us, your knowledge of their substance use, unless the patient has signed consent or that there are proceedings occurring and we've received an appropriate subpoena and court order. So although 42 CFR Part 2 does not explicitly address or allow reporting of abuse, neglect, or exploitation of elder and other vulnerable adults, if your state does mandate reporting of this type of abuse, then you should make the report without disclosing any patient identifying information. So this could mean that you have to make the report anonymously due to these limitations, or if you aren't allowed to make an anonymous report in your state, then this is why it becomes essential to make sure that you're talking to your supervisor, kind of working through this with them so you can make sure you're compliant with both the confidentiality piece and the mandatory reporting piece, because you may be able to provide without it having to be anonymous. You just can't say how you came into that information or what your relationship is with the patient where it might disclose their substance use treatment or substance use disorder. So it does allow for reporting to law enforcement of any threat, attempt, or commission of a crime, either toward program staff or on the program premises. So it specifically allows you to report the incident, including the person's name, address, last known whereabouts, and status or presence as a patient of the program. So here it specifically does allow you to say, you know this person and that they are, a patient of your current program. But beyond that, the only information to be disclosed is specific to the incident or threat, and not divulging the rest of it. So with duty to warn, you can make reports to law enforcement about an immediate threat to the health or safety of an individual or the public if patient identifying information is not disclosed. So keep in mind that immediate threats to health or safety that do not involve a medical emergency or crime are not addressed in the federal regulations. So again, this has to be addressed on a case-by-case basis. And just like we mentioned a couple of slides ago, any type of criminal charges that may stem from a report that we had to make may trigger a request to disclose additional information, and that's when it falls back to our policies on how we handle when we receive a subpoena or a court order. So we know that 42 CFR, pretty much because it's the most restrictive and it's a federal law, that's what we have to comply with the most. It's the most stringent for protecting a patient's confidentiality, but there are some pieces in HIPAA that aren't spelled out in 42 CFR Part 2, and so we do have to keep compliance with that as well. So it's not so much about the substance use diagnosis and treatment. What's mentioned in HIPAA is more specific around reporting and a couple of the steps that you may have to take. So it differentiates between permitting mandatory reporting of child abuse and neglect versus permitting disclosure of protected health information of an individual whom we reasonably believe to be a victim of abuse, neglect, or domestic violence of an adult victim. And so just to make sure that that's clear, is that they do differentiate between, yes, you're allowed to make the mandatory report, but here's the parameters for whether or not you're going to be disclosing any PHI. So the stipulations, this is a lot of regulatory jargon that essentially says, to the extent that a disclosure is required by your state laws and the disclosure complies with and is limited to the relevant requirements of that law, then the individual agrees to the disclosure, or to the extent the disclosure is expressly authorized by statute and regulation, and the covered entity, which is you as our employee, CBH is the full agency, in our professional judgment, believe that the disclosure is necessary to prevent serious harm to the individual or other potential victims, or the individual is unable to agree because of incapacity, and a law enforcement officer or other public health official authorized to receive the report represents that the protected health information is not intended to be used against the individual. And that immediate enforcement activity that depends upon the disclosure would be materially and adversely affected by waiting until the individual is able to agree to the disclosure. So essentially, this is explaining, yes, you're allowed to make a disclosure as required by your state laws, but here's your stipulations. The person has to agree, which means you have to inform the patient before you even make that report. And then to the extent that you're allowed to do that by your state laws, you still have to maintain confidentiality of the other things that aren't related to the specific reportable event or suspicion. And the only time that you may not include the individual is if it seems like it's going to be a greater risk to them if you involve them. And then it goes back to, if the person is incapable, they don't have the capacity to be able to agree, then basic measures are taken, because if it's just, it could be a greater risk to not disclose than to disclose. And again, it's limited to just the information related to what you're reporting. So any covered entity, which again, us as an agency, you as an individual that works for us, a covered entity, when we make a disclosure that's permitted by that paragraph that we just went through, you have to promptly inform the individual that such a report has been made or will be made, except what I was just talking about, where it could place the individual at greater risk of serious harm if you were to let them know and involve them in the reporting. Or if the individual, because they don't have the capacity to make their own decisions or take care of themselves, and possibly they have a family member who's legally responsible for that, or some other sort of caretaker that is who you normally would provide the information, that if you reasonably believe that that family member or that personal representative for that patient is who is actually responsible for the abuse, neglect, or other injury. And so obviously, if you let that person know and you're making a report about them as a perpetrator, then that could put the victim at much greater risk of injury, abuse, continuing getting worse. And so this is where it starts to get gray, and you'll see even when we go through case scenarios and stuff, why it's essential to talk to your treatment team as it's appropriate, and then to always kind of walk through this with your supervisor. And I listed our different internal policies and procedures that touch on mandatory reporting and duty to warn. So within incident reporting, with incident reporting, it's addressed as part of critical patient incidents, the death notification form, and the steps you take if it's an allegation of abuse or neglect of a patient by an employee of ours. It's also referenced in our confidentiality policies, including disclosure of confidential patient information with or without written consent, responding to subpoenas, search warrants, investigations, and other legal actions. That's one single policy. And then, as I've mentioned, we have that in service, and those slides and those resources are available to you at any time. That's our confidentiality of substance use disorder patient records. So in all circumstances of mandatory reporting, permissive reporting, duty to warn, all those different examples we just talked about, you're responsible for complying with our internal policies as well as those federal and state laws and your code of ethics for your professional licensing or certification board, if that applies to you. And this is, because there can be so many unique details and you have to often make a decision on a case-by-case basis, it's not just to make sure that you're compliant, it's to make sure you're also getting the resources and support that you may need for yourself or your patient, and you're not expected to automatically know how to handle every single case and manage it on your own. So what exactly is your responsibility to your patients? Well, all patients get information about confidentiality and when they're first admitted, but it's important to make sure this education is ongoing, not just what their protections are, but what the limitations are as well that we have and the obligations that we may have for mandatory reporting. Great time to review this is not just admission, but to make it like a regular occurring topic every once in a while, or anytime a release is signed, it's a great time to go over making sure the patient understands those protections and limitations. And then when it's appropriate, and to notify patients when we are taking these different steps to make a report and include them in the process, ensure they understand what may be required of them and what's required of us. And again, just keeping in mind whether they are the victim or the perpetrator or a past victim, you're going to have to weigh on a case-by-case basis sometimes of, is it a greater risk to the person if you involve them in the process? So different types of abuse and reportable acts. Initially, we're going to start with child abuse and neglect and then move into vulnerable adult and domestic violence and a couple of other examples. But across the country, we use this standard definition, all states do, from CAPTA to define child abuse and neglect. So I'm not going to go through every single one of these. These are on here more as a resource for you to be able to go back and reference, to be able to use these different examples in educating patients. So, I think we understand what physical abuse is, but it can be more of a gray area when we talk about something like neglect or even with sexual abuse, that with a minor, this includes any type of persuasion, inducement, enticement, or coercion of a child to engage in any type of sexually explicit conduct. So not just a physical act of sexual abuse, but all of these other instances apply when we're talking about children. And many states have added sex trafficking, human trafficking into the protections and into the definitions. So CAPTA is the Child Abuse Prevention and Treatment Act, originally enacted in 1974. This helped to define and establish funding, resources, research, training, etc., specific to child abuse and neglect. So this has been amended multiple times, and we just talked about the example of adding victims of human trafficking. And then in 2016, they also added to ensure the safety and well-being of infants affected by substance use, such as neonatal abstinence syndrome and fetal alcohol spectrum disorder, FASD. So if you're in a state where they've already started working on their plan of safe care, this came from the CARE Act in 2016. So that definition from CAPTA and the work CAPTA has done is essentially states were required to enact mandatory reporting laws to be able to participate in, receive any funding, get the support and resources from CAPTA. And so every single state, territory, and DC all have some sort of form of mandatory child abuse and neglect reporting. And so pretty much all states designate various types of positions or professions who are mandatory reporters, like physicians and teachers. And then 18 states and Puerto Rico, any person is required to report suspected child abuse and neglect. So any resident, regardless of if you are work in one of those specific professions. And then all the other states and territories in DC permit reporting by any person, but don't mandate it outside of the designated professions. So a citizen may be encouraged to report, but there's not any legal mandate for them to do so if they're not one of those professions. So I'm not going to read through all of these stats. Again, this is just some resources for you guys, but per the National Children's Alliance 2015, it was estimated over 1,600 children died from abuse and neglect in the U.S. Children in the first year of their life had the highest rate of victimization of 24 per 1,000 children in the national population of the same age. And a parent of the child victim was the perpetrator in 78% of the substantiated cases of child maltreatment. And then the last one, which I thought was also really concerning and important to be aware of, is that according to the World Health Organization, children with disabilities are almost 4 times more likely to experience some sort of violence than non-disabled children are. So one thing that I think specifically often comes up for us is a person's drug use a type of child abuse? So this can be in different forms, such as using while they're pregnant, it's prenatal exposure, child exposure to drug use activities going on in the home, neglect due to the parent or caregiver being impaired, and then child exposure to drug-related activities such as manufacturing or trafficking. So your state may also have a bigger definition of abuse and neglect beyond that CAPTA definition we reviewed. So again, they may add some of those things we just saw on the previous slide related to substance use. They may consider failure to educate or failure to obtain medical treatment as forms of neglect. And then, is it required that you report to Child Protective Services or law enforcement or both? And then last, are there exceptions to the definition? Some states do specify it's neglect unless the family doesn't have a financial ability to be able to provide appropriate care, or what's occurred is reasonable physical discipline by a caregiver. So failure to report, with mandatory reporting for identified professionals or professions, failure to report suspected child abuse can result in criminal liability, although it's usually a misdemeanor with a fine, but it can also result in civil liability. But all states are required to have immunity that states if you do make a report of child abuse or suspected, and it's in good faith, whether you work in one of those professions or you're a citizen, just in that community, and you make a good faith report, that you are immune from criminal and civil liability. All right, for these next couple of case scenarios we're going to go through, I'm going to turn it over to Christine.
Hey guys, like Michelle said, we're going to talk through a few case scenarios. Some of these case scenarios mimic some actual scenarios that have come up in some of our locations. And we thought this would be useful to kind of demonstrate, how we make decisions on whether or not to report. We recognize that that can be challenging a lot of times. I think we're very sensitive to the impact that that has on our therapeutic relationship with patients when we're called to make a report, and the impact it might have on their likelihood to remain in treatment with us. So we do want to emphasize, that, and I know Michelle has mentioned it several times, that how much we encourage you to involve your team and involve your supervisor, involve us, and really consult in these cases and making these decisions around reporting. So we're going to talk through a few, and I'm going to have you guys write in through the chat function kind of what your thoughts are on whether or not we would report, or whether you feel you would make a report in these various situations. So the first scenario. A patient informs her counselor that she has been drinking heavily following a recent breakup. The patient states that she just doesn't want to feel the pain and has been drinking to the point of blackout. The counselor is aware that the patient lives alone and is the sole caretaker for 2 children under the age of 5. When asked about where the children are when the patient blacks out, the patient responds, "Oh, they're in bed at that point." So is this something that you feel you should report? I'm going to give you guys some time to chime in with the chat, and then we'll talk about your responses and what we think might be the best response in this scenario. So I'm not seeing any responses yet. I'm going to just encourage you guys to chime in with whatever you think. There's no kind of right or wrong. This is really just for some discussion points here. We're going to talk through it, but I would like to see some responses. If you could take a minute just to send in a quick chat with, it can just be a simple yes or no, or whatever your thoughts are on this scenario. All right, so we've gotten a few responses in here, a couple no's and one that said, "I would think you would not report." So in this scenario, and this does get into that territory of at what point does a person's or a parent's substance use border on a reportable issue. And, you know, really it comes down to their capacity to care for their children and respond appropriately to their children's cues. So in this case, I felt like, yes, it was a possible reporting issue because this person's pattern of alcohol use would significantly impair their ability to respond to the needs and the cues of their children or to respond appropriately in an emergency. You know, if their child were to wake up with a medical emergency, if there was a house fire or something along those lines, they would not be in a position to appropriately respond in that case. So somebody else chimes in with, I think it sounds like neglect. The children can wake up while she's blacked out. So yes, kind of along those same lines, an inability to appropriately respond if something were to happen. So the next case scenario, a patient informs you that her boyfriend recently had an overdose in the home. Patient acknowledges that her 6-year-old son was at home at the time, stating she was worried that her boyfriend might die and that her son would see the dead body. Patient states that the boyfriend eventually revived and that no emergency services were called. Should you report? So let me know your thoughts on that one. So we've gotten 2 no's so far. Does anyone else want to chime in? So someone said, depends on how recent it was and if the boyfriend lives in the home. So in this circumstance, the boyfriend was in the home at the time with the child when he overdosed. So my response to this was yes. It seems likely from these circumstances that the illegal use, drug use activity, overdose was occurring in the home with the child present, that the child had the potential to be exposed to illegal substances, be exposed to drug use activities, and in this case, also being exposed to their adverse consequences. So somebody else chimed in, he was actively using with the child present. I would say yes, and that's kind of along the same lines as I was thinking there as well. I do want to point out that these are kind of intentionally not clear, you know, black and white scenarios. It takes a little bit of thought to really kind of make determinations on when substance use kind of borders on that reportable issue there. So case scenario number 3, a patient with an active Child Protective Service case has recently gained back custody of her children. There's not an active release for the counselor or program to talk to the Child Protective Services about the patient's treatment. The patient's recent drug screens have been returning diluted, and the staff suspect that the patient may be trying to falsify drug screens in order to avoid detection of illicit substances. Is this a case where you would report? So we've had a few people say no. We had somebody say with no release, then it would be a no. Someone said no, it's not clear that they are using while the children are present, and another no. So in this case, I absolutely agree that this would be a no. Even if it was proven that the patient had been falsifying their drug screens, the act of falsifying a drug screen does not in and of itself, and even substance use in and of itself, does not result in child endangerment, abuse, or neglect. So additional indications or suspicions that the patient was using illegal substances and using in a way that could result in child endangerment or neglect would need to be present in this situation. So case scenario number 4, a couple that attends the clinic frequently bring their 1-year-old child with them when they come in for services. A staff member notices when the couple arrives that their child is in a front-facing car seat. The seat appears secure and age-appropriate, but based on the child's age and suspected weight, it's likely that the child should be in a rear-facing seat according to state guidelines. Is this a situation where you would report? So we had someone respond with no, another no, educate the parents. Somebody responded, good question, ... Someone said agreed, educate the parents first. So in this case, I said maybe, likely not. Transporting a child without appropriate child restraints could definitely be grounds for a mandated report. I tend to think more of, having a child completely unrestrained. In this case, the child was in an appropriate restraint. It just wasn't installed within the recommended guidelines, possibly not even within state law about that. In this case, simple patient education may be enough to immediately resolve the situation, which I think if that's the case, then it would not require a report. So with that, I'll pass it back over to Michelle, who's going to get into elder and vulnerable adult abuse.
Great, thank you, Christine. And just a little add-on that could change the situation even further with that last scenario is even if the child was not in appropriate restraints, again, considering intent of the parents and getting that further information. Is it lack of education or understanding? Is it that they can't afford to purchase new, more age-appropriate restraints, and they just need like a good referral and education on how to properly install that? So, that adds that little piece of, is it potentially a type of neglect, but due to financial problems, and that answer could change the outcome of what you may or may not report. Okay, so getting into elder and vulnerable adult abuse, as I mentioned, although I'm going to give you a couple of data points that are a little different about the prevalence. Otherwise, I've put the definition and the types together because the language is very similar, if not identical, in most states. So, definition of elder and vulnerable adult abuse is defined as any knowing, intentional, or negligent act by a caregiver or any other person that causes harm or a serious risk of harm to a vulnerable adult. Again, legislatures in all 50 states have passed some form of elder abuse prevention laws. So prevention, education, or resources, not necessarily mandatory reporting. So this originated due to numerous accounts of maltreatment. Many years ago, it led policymakers to pass a series of laws intended to protect elderly victims, going back to the Federal Older American Act of 1965, and then the creation of the Vulnerable Elder Rights Protection Program in 1992. So this legislation promoted advocacy efforts through ombudsman offices, prevention programs, and legal assistance on behalf of older Americans, and also offered federal funding incentives, which made it possible for states to develop and maintain programs designed to assist and support the elderly. And in many respects, you'll notice that a lot of the language, the description of the types of abuse sounds similar to child abuse and neglect, and that's because it was, in many cases, patterned after legislation designed to address the problem of child abuse and neglect. And it often involves the combined efforts of not just criminal justice officials investigating a potential crime, but also social services staff and agencies that are there to provide those resources and support. So prevalence of elder abuse, just to hit on a couple of these points, is according to national data, elder abuse occurs primarily in domestic situations with perpetrators most likely being adult children of the victim at nearly 33%. And crimes committed by family members and caretakers occur far more frequently than crimes who are perpetrated by complete strangers. However, those crimes committed by family members and caretakers are actually the least reported and prosecuted. Only 1 in 14 cases are ever even reported, and only 1 in 25 cases of financial exploitation are ever reported. And I'll give you guys a better definition of what something like financial exploitation could mean. So that was a snapshot of the prevalence of elder abuse, and this is more generally about vulnerable adults. So there was a 2012 survey of more than 7,000 adults, and this was a mix of people who may have been individuals who themselves had a disability, family or caregivers of someone with a disability, law enforcement, advocates and support agencies that may address this type of abuse or be the ones who take action as a result. And more than 70% of respondents with a disability reported having been abused, and 63% of family members reported their loved one had been abused. More than 90% of people with disabilities who were victims of abuse said that they had experienced such abuse on multiple occasions. And as many as 46% said it was too frequent for them to even count how many times it had happened to them. Nearly 63% of victims did not report the abuse to authorities. And even in scenarios where the family of the victim knew that abuse had occurred, 48% of them still did not report it. And one of the pieces that I thought was the most concerning is that the most underreported types of abuse were physical and sexual, and the most common reason for not reporting was fear, but the higher rate of 58% was because they believed nothing would happen to the perpetrator. And I think that's something we have to take into account, that it's not just that fear of what's going to happen to me. It's not just the shame of, did I let this happen to myself? Did I cause this, bring this on myself? But that that's almost 60% that feel like there's no point in even telling anybody because nobody's going to do anything about it. So different types of abuse you can see from the descriptions with physical abuse, sexual abuse, and neglect, that that language is very similar to what was on the other slide about child abuse. And so the main ones I wanted to kind of go through are exploitation and financial abuse. So this can be that their family member, caregiver, whoever it is that is abusing them, is illegally taking, misusing, or concealing their actual money or property, assets, for their own or someone else's benefit. And even if actions are technically legal, so possibly the victim has designated this person to take care of their finances. If the perpetrator coerces, lies, threatens the victim in order to obtain and maintain that role of being responsible for their finances and then misusing it for their own benefit, it doesn't matter if how it occurred originally was legal. The fact is they are abusing it now, turned it into something illegal that is still a type of abuse. And then with self-neglect, so that's not going to be a criminal report. That could be a report to Adult Protective Services for support and resources, is that the person is failing to take care of themselves. So not just not getting medical care or not taking their medications as they're supposed to. This could include poor nutrition, not taking care of their personal hygiene, or their basic daily needs to be able to live and to function, is self-neglect. So it's a type of self-abuse that often it is just that the person may not know how to obtain those resources or where to even start asking. And so again, that is more to make sure that they get the help that they need. It's not anything criminal. So again, I've provided a link there at the bottom that gives you a mandatory reporting chart that was updated in 2015, but you would still want to double check in your state that whether suspected abuse, neglect, or exploitation of an older person or vulnerable adult should always be reported to the local Adult Protective Services agency or local law enforcement, or both, as required by your state's laws. Okay, I'm going to switch this back to Christine for just a second to go through this case scenario.
Okay, so in this case scenario, a patient informs you of some concern she has about her cousin's caretaking of their elderly grandfather. The patient reports that the cousin is supposed to care for their grandfather while the patient is at work. The patient states that there have been several times the grandfather's medications have gone missing or were not administered in the appropriate time frames. The patient reports they have also come home and the grandfather has soiled himself and not been properly cleaned, and that the cousin recently failed to take their grandfather to a medical appointment. The patient is frustrated because of her need to work and lack of options for other caretakers. Should you report? So go ahead and chime in the chat and let us know what you think about this one. Okay, so we've gotten a couple responses in. So a couple people said yes. One person said have a good talk with the cousin first, but medication and doctor appointments being missed could put the grandfather at risk. So in this situation, I said yes, that there is some clear neglect of an elderly and vulnerable adult occurring in this situation. Because 42 CFR Part 2 doesn't make allowances for disclosing Part 2 protected information in the case of elder abuse. This is one of those cases that's not addressed as a exception to patient consent requirements. So this is a case where the report would need to be made without identifying the patient as having a substance use disorder or receiving substance use disorder treatment. So the report should be made without identifying the context of how the information was obtained. But I think, this situation brings up a couple things that I think we sometimes run into. One is that sometimes we get reports that aren't necessarily where it isn't the patient themselves that is the perpetrator of the abuse or neglect. So in this case, we may feel strongly that our patient is, doing everything they can, and we may feel a lot of empathy because they're really trying to work hard and they don't have any options. And so it may make us feel very conflicted about our role and responsibility to report in situations like this. But the reality is that they are leaving their grandfather in the care of somebody who is being neglectful. They're not taking them to medical appointments. They're not cleaning them properly. They're not providing them, or possibly stealing medication in this case. So this would be a clear area of report.
All right, thank you, Christine. So getting into domestic violence, intimate partner violence, dating violence, wanted to include all of those versions of the language because it can vary by state, but it can also represent separate definitions of the protections for each of those types of relationships. So domestic violence is not just physical, it's a pattern of physical, sexual, and psychological and emotional mistreatment of one intimate partner by another with the intent to control and cause harm. This abuse of power harms the psychological, social, economic, sexual, and physical well-being of the victim, and it most often is going to escalate in frequency and severity, and without some sort of intervention, it can often lead to death. So just to give you a little history of how we've addressed domestic violence in the U.S. and a snapshot of some of the different current laws is that we actually did not, all of the states did not make it illegal for a man to beat his wife in the United States until 1920. So we've made great progress, but that can be shocking to consider that wasn't necessarily all that long ago, that we still had states holding out until 1920 who had not necessarily made it illegal yet. But it took another 50 years before we truly started addressing domestic violence as more of a criminal matter rather than a family matter. So now all states have some sort of domestic violence laws for protection and reporting, but those specifics, just like we've talked about, are going to vary by state. So as of 1993, all states have criminalized marital rape. 30 states and DC have domestic violence laws that use gender-neutral language and apply to household members and dating partners. So gender-neutral meaning you may still have protections if you're in a same-sex relationship. Household members, that means that you do have protections if you live together, but you aren't necessarily married. And fortunately, more states are even adding that dating partners. You don't have to share a child, you don't have to live together, you don't have to be married, just dating partners often are protected as well. Another 18 states have domestic violence laws that, while they did make the language gender neutral, it only applies to household members, living together, actually legally married. And then we still have 4 states that have explicitly excluded same-sex survivors from protection. When we get into the prevalence here in the next couple of slides, I think the prevalence, and then when you look at that, we still have 4 states kind of holding out, and it's not just that they haven't yet revisited those laws to make the language gender neutral, it's that they've explicitly excluded same-sex survivors from having any type of protection. Protection is alarming. And gives you an understanding of why sometimes people in same-sex relationships where violence is occurring feel like there's no point in reporting it. So the prevalence of domestic violence is 1 in 3 women or 1 in 4 men in the U.S. have experienced some form of physical violence by an intimate partner. And on a typical day, domestic violence hotlines receive approximately 21,000 calls or 15 calls per minute. And so if you think about what we just said about often, you know, the fear of even talking about it or trying to take any type of steps to get yourself out of the situation results in a lot of underreporting. So that number is a whole lot higher of who actually needs those resources. This is simply the people who have taken that step to reach out. Gay and bisexual men experience domestic violence in 2 of 5 intimate relationships, which is the same incidence as heterosexual women in intimate relationships. And at least 50% of the lesbian population has experienced or will experience domestic violence at some point in their lives. And then the last point to touch on is 72% of all murder-suicides involved an intimate partner, and 94% of the victims of these crimes are female. So I included a couple of links at the bottom for you if you want to look at some more data and resources. And the second one down there is specifically a fact sheet about the prevalence with in same-sex relationships. So different types of domestic violence, as you can see, the physical, sexual, psychological, those examples are very similar to the definitions that we saw that were for elder abuse, vulnerable adult, and even children. But environmental is something that I want to talk about because this one can be harder to understand even for the person that it's happening to. They may not necessarily realize that it's abusive. So this can be anything from isolation from family and friends and social activities to more extreme of monitoring and limiting their telephone calls and communications with other people. The person can't have their own mail, destroying property or things that are important to the victim, not allowing the victim their own transportation or direct access to any of the finances, and even monitoring how the victim dresses, makeup, how they present themselves. So really, the person may never physically touch them and physically abuse them, but this type of abuse can be so damaging psychologically and emotionally of the person feeling like they have no rights, they have no say-so, they have no voice, and can't or don't know how to even make decisions for themselves to take care of themselves, of how that can have such a ripple effect on the person's well-being and the trauma that they are experiencing and will need to address as part of their treatment, likely. So in reporting domestic violence, this is one that it varies by state. You may be required to notify Adult Protective Services. You may be required to contact local law enforcement or both. Even if your state does not mandate reporting of you as a citizen or professional, you're still responsible for reporting any suspected or known child abuse and neglect that may be occurring in that household, which data does show that in a household where domestic violence is occurring between intimate partners, the chance of child abuse occurring in that same household is much higher. And even if you're technically not mandated to report it to law enforcement, it's still really important to assess this and provide education and support and resources to your patients, make appropriate referrals if they're willing to accept. And you may even have a situation where you're not mandated to report, but a patient is ready to take that step of asking for help and getting out of the situation. And they ask for your help in making a report. They're willing to be part of the report. They want to make the voluntary report on themselves. And I think it's completely appropriate to offer them help in doing that in the context of your clinical relationship with them in the office. And so they've signed consent. They're the ones doing the talking. You're there to provide support. If they've signed consent, then you can verify certain things that may need to be verified for the person to access different resources. And so I think in a situation like that, it could be completely appropriate for you to assist and support them in making that voluntary personal report. Okay, this takes us to case scenario 6.
All right, so in this scenario, we have a patient who presents to the dosing window wearing big sunglasses. When they were asked to remove her sunglasses. Significant bruising on her face is revealed. Patient later informs her counselor that she has been the victim of intimate partner violence. So is this a situation where you would report? Go ahead and chime in the chat function with your thoughts. All right, so we've had a few responses. A couple people have said just a straight yes. One said if state laws require reporting, then yes. Someone said it could be potentially dangerous at that exact time. I would have a conversation with her first before reporting. And a couple of people said in Idaho, because of Idaho law, no, you would not. So the response we put here for this one was maybe, but most likely no. You know, this is one case scenario that's kind of intentionally not black or white, because state law varies so much on this issue. So while there are several states that have mandatory reporting laws for domestic violence, if you really dig into those, a lot of times those laws are restricted to either the reporting of very specific wounds or injuries, or they're restricted to just those healthcare professionals that are involved in treating that injury. But regardless, it's really important that you be aware of what your state laws are, because there are some states that have extended mandated reporting requirements to include nurses in whatever setting, to include mental health professionals and social workers, and may include any injury that's believed to be the result of non-accidental means. The other reason why it's really important to be up to date on kind of what your state law is because state laws can change. Kentucky is a great example of this. They just had a law that changed in 2017. So it's really important that you're keeping up to date on this as well. And Kentucky is an example where there were some mandates for mental health professionals to report. And now that's been changed to a mandate to provide education and provide resources instead. So, you know, I think intimate partner violence in particular is just a very sensitive issue. As someone noted in the comments, you know, it could be risky sometimes to make reports. If that report is not handled appropriately, it could put somebody at higher risk. Also, mandated reporting is, you know, believed to sometimes contribute to an unwillingness to make reports to healthcare professionals or helping professionals. And so there's a very different lines of thoughts about whether mandated reporting laws are helpful to victims of domestic violence. So, you know, I know we've said it multiple times throughout this training, but it's with domestic violence, and I think with any of these, it's very important that you are familiar with your state statutes. You know, we're providing a pretty broad overview today of some concepts around mandated reporting, but you have some responsibility to make sure that you know what your state requirements are, and also what the requirements are specific to your license or your credentials in your state, because that can vary even within your state. So this is another case where exception to the patient consent requirements in 42 CFR Part 2 does not exist. So if we were to make a report, if we felt that we were mandated or under a requirement to report in this situation, we would want to make that report in a way that does not disclose Part 2 protected information. There is a link on here if you want to look into a little bit more about your states. This is a link that tells you a little bit about each state requirements on domestic violence. I do want to note, however, that it was published in 2010. So again, there could have been changes since that time, so just take that with a grain of salt. You know, Kentucky again changed in 2017, so it may not be completely up to date, but it might give you a sense of kind of what your state says about domestic violence reporting. So I'll pass it back over to Michelle.
Great, thank you, Christine. And just to add a couple of notes on that, I know Christine mentioned this earlier, but each of these case scenarios on some level, an answer could go either way. And we promise we did not do that on purpose for it to be frustrating, but really to drive home the fact that it is such a case-by-case basis of not only is it abuse, what kind of abuse is that? What should I report? What kind of referrals or resources do I provide for the patient? How much do I involve the patient? You know, the slightest little difference in what that scenario is can impact what actions you have to take. And that's why it's so important, again, for you to not try to do that by yourself. Nobody expects you to. And it's just better to get that support to make sure you're following along with everything. If you think possibly in your state that, for example, like the example that Christine gave, where Kentucky's law changed from mandatory reporting of domestic violence to mandatory reaction to domestic violence reports of providing education and resources to the patient that are specifically outlined in regulation. That changes like that, if you think the state laws for reporting conflict in some way with maybe what your licensing board says that you have to do or have to report in your ethical guidelines, then I would encourage you to talk with your board and ask them, is it simply that this has not been changed? Are you planning to change this? You know, which one is correct as far as to protect my license? So just keeping that in mind, you know, absolutely ask those kind of questions. Sometimes different laws are passed and not everybody's informed or can move at the same pace to make sure all of the related regulations or statutes kind of change at the same simultaneously. So sometimes it can leave even more of a little gray area on what do I do first or who do I ask. Okay, getting into duty to warn and kind of looking at that definition and how this originally occurred to kind of set in motion this duty, the fact that we have duty to warn currently. Sorry. So the legal precedent of this concept of duty to warn was set in the case of Tarasoff versus Regents at the University of California back in the late 70s. In this case, a University of California student was seeing a psychologist through the University Student Health Center. And because a young woman named Tatiana Tarasoff had spurned his affections. So this individual was seeking this care from a psychologist to discuss this. And the psychologist reasoned that this student, this patient of theirs, was dangerous because of his pathological attachment to Tarasoff and because he intended to purchase a gun, and he notified the police both verbally and in writing. The police questioned Potter and found him to be rational. They made him promise to stay away from Tarasoff. However, 2 months later, Potter killed Tarasoff, and when her parents attempted to sue the University of California and health center staff members and the police, the courts completely dismissed the case originally. But following that, the family of the victim actually appealed to the Supreme Court of California, asserting that the defendant had a duty to warn Ms. Tarasoff. So they felt like, you know, the therapist or the psychologist, the school, police, all should have been required to warn Ms. Tarasoff, or her family at least, of the danger, and that they should have persisted to ensure his confinement. And in a 1974 ruling, the court held that the therapist indeed did have a duty to warn Ms. Tarasoff when the defendants and several, literally an amicus brief is literally means friends of the court. It's when individuals who aren't necessarily parties directly involved with the court proceedings still file briefs with the court in support of and a petition for a rehearing, and the court took the unusual step of actually granting the rehearing. And in the second ruling, the court released the police from liability without really providing any explanation, and more broadly formulated the duty to be a therapist, imposing a duty to use reasonable care to protect third parties against dangers posed by patients. So again, even though they were allowed a rehearing and it was reviewed, they still released the police from the liability and put that on us as the therapists, as social workers, as counselors, and us having the responsibility of duty to warn to protect a third party. So just additional notes about the effects of this case is with this case, it imposed an affirmative duty on therapists to warn a potential victim of intended harm by the client, stating that the right to confidentiality ends when the public peril begins. This legal decision sets an affirmative duty precedent in cases of harm to others that is generally accepted within the social work profession. This case indicates that notifying police is not sufficient action for you to take in protecting the counselor from a lawsuit if the client's threat is carried out. So notifying police is not sufficient. This reinforces we have this responsibility, we have this duty to notify law enforcement and to notify the intended victim or someone like an appropriate family member, someone who can get that information and help protect that victim. This map gives you a snapshot, and I also included the link at the bottom to show you what the different levels of reporting are related to duty to warn in each state, whether it's mandatory or permissive, or there is no duty and requirement to warn at all. And so as you can see, most of them do actually make it mandatory, but there are still a number of states that don't, and then you have a couple of outliers that have no requirements for duty to warn.
Here is just duty to warn, protect by state, and we actually had this same slide in the confidentiality presentation or training that we did last year, but we wanted to include it again here since it's relevant to this topic, and this just shows you a map, at least as of 2015, of which states have duty to protect and warn laws that are mandatory, which have laws that are permissive, and which either have no duty to protect or warn in their state statutes, or in the case of Georgia, may have something kind of other altogether. So there is a link on there if you want to look up the specific, I believe it has the specific language in each state. So if you want to check that out and kind of see which professions are specifically identified in your state, I would definitely encourage you to do that. So duty to warn refers to the responsibilities of a counselor or therapist to breach confidentiality if a client or other identifiable person is in clear or imminent danger. I'm on the next slide, by the way. I don't know if Michelle is controlling the slide, so it may not, but hopefully all of you have it printed in front of you as well. In situations where there is clear evidence of danger to the client or other persons, the counselor must determine the degree of seriousness of the threat and notify the person in danger and others who are in a position to protect that person from harm. So, you know, one of the things I want to highlight about the Tarasoff case is, you know, this psychologist did respond to their client's you know, identified risk. They contacted the police both verbally and in writing. They made some recommendations that this person be involuntarily involuntarily committed, but they did not inform the intended victim. So duty to warn does extend to a responsibility to inform an identifiable person that may be at risk. And if you notice in the second bullet point, it even extends to others that might be in a position to protect that person from harm. So that it could include family members as well as the identifiable victim. So remember that you may only disclose the information that's absolutely necessary and that you are otherwise liable for protecting a patient's confidentiality. You know, the mandates around duty to warn do not allow you to just give every and all information that we have on that patient. It has to be relevant to the actual situation, has to be relevant to protecting the potential victim. And because 42 CFR Part 2, again, does not have specific allowances in duty to warn situations to exempt your requirement to obtain patient consent, you may have to make that disclosure without identifying that person as being a patient of our program or as having a substance use disorder. Because each case is so different, it's really important that you always discuss with your supervisor the situation prior to taking any action or making any notifications. And, you know, supervisors, it's really important for you guys to reach out to Brant and Mary and receive additional consultation from the program sponsor as well before taking action because of the sensitivity of these cases. So we'll move on to another case scenario. So case scenario number 7, a patient reveals during a counseling session that he has recently discovered that his wife has been cheating on him. In discussing the issue with the patient, the patient makes several statements indicating a desire and possibly an intent to harm or kill his wife. This is a patient with a known propensity for violence. The program has information on the wife's name and contact information due to the patient listing his wife as an emergency contact. So is this a case where you should make a report, and to whom would you make a report in this situation? So I'll give you guys a minute to chime in with your answers.
Unmuted.
So we've had one response. Does anyone else want to chime in with what they might do in this situation? All right, so we've had a few responses. So one person said in Louisiana they would make the report to the wife. Someone said yes, report, and then said police, question mark. Someone responded yes, and someone responded to non-emergency police. So in this situation, we said yes, that this would be a case where a duty to warn exists. And in this case, a duty to warn the potential victim appears to be present. And because in this case, there is an identifiable victim, notifying the police may not be sufficient. An attempt to notify the potential victim should also be made. So, you know, again, going back to Tarasoff, and what was so landmark about Tarasoff is that the therapist was found, or the psychologist was found, that or they determined that his notification to the police was not sufficient because the psychologist had information about the potential victim. They knew the potential victim's name. They had reasonable mechanisms to get in touch with that victim. It was determined that that therapist or that psychologist also had a duty to warn the potential victim. So, again, I think this is a situation where you need to be very clear on what your state statutes are and also what your specific licensure duties may be. This also gets into a territory of ethics within our profession as well as state statutes. So this is also another case where there does not exist an exception to patient consent requirements does not exist in 42 CFR Part 2. So again, we would want to make the report to the extent that it's possible in a way that's not going to disclose any Part 2 protected information. So, this is always a challenge. All of these cases are a challenging balancing act of all of our responsibilities to patient confidentiality, to those federal protections, our responsibilities to our field and our professions, and our responsibilities under our various state laws as well. So somebody else chimed in with, I always say err on the side of caution, and in my opinion, having a desire to harm would constitute a need to report to authorities in life. And I should also mention that I think it would be appropriate to not only contact the potential victim, but probably police as well in this situation.
Great. Thank you, Christine, and thank you for taking over. Sorry about that, everybody. I'm not sure what happened with my audio there. And we got a great question from this morning session of what if there is intent that the patient shares with you, but not a specific victim. And so without a specific victim, it is not necessarily this formal duty to warn where you are supposed to try to warn the victim and other people like family who may be able to help notify them or protect them. This goes back to collecting appropriate information and assessing the situation and visiting this with your supervisor if needed. Because if the person has intent and has access to a weapon or to carry out their plan, but there's not a specific victim, there may still be something that is reportable to law enforcement to protect the general public. So just to keep that in mind. Okay, I mentioned these examples at the beginning, so I just wanted to kind of hop back to this as a reminder that I put a link on here that you can take a look at for the civil and criminal reporting or action requirements around human trafficking for your state. And then different states can have these kind of little nuances with different laws. They may be the only state in the whole country that has something as specific as, for example, the state that I mentioned at the beginning was California, that this is more recent where all mental health professionals, counselors are required to report to police now any patient who discloses to them that they have ever viewed child pornography. That is kind of a landmark thing that's being addressed, concerned, debated against, because that can put a counselor in a bad situation of how do you address this? How do you maintain any type of report if literally they could report that they singly viewed something a single time 10 years ago, and now if you work in California, you may be required to actually report that. And then I'd use Kentucky as another example of how tweaks to the language can change that. As I mentioned, Kentucky changed the mandate to report domestic violence to now mandate to provide education and resources. However, if a patient dies and it is suspected or known that their death is related to domestic or dating violence that had been reported to you, then you are required to report that in our state. So just to hit on some of the clinical considerations that can occur when you're dealing with mandatory reporting, duty to warn, all these different scenarios is, how do you develop and maintain that therapeutic alliance if a patient feels like there is something that they have shared with you and now you've made a report? and whether that was with or without their knowledge. And if it is without their knowledge, then why was it without their knowledge? You know, helping patients to understand, again, our limitations and our requirements, as well as their rights as far as confidentiality, but also helping them to better understand the importance of safety of themselves, their children, their family, and why it is not a betrayal of the therapeutic alliance. This is about safety, and that you are obligated to help protect them and these other individuals, such as children or vulnerable adults. Also, it definitely takes a different turn in treatment, potentially, if your patient is sharing this information with you because they are a victim currently experiencing some sort of abuse, they're a survivor of past abuse, or they are actually the perpetrator of the abuse. This can impact what kind of report you make, what type of information you share with the patient, and kind of where that goes in treatment. You know, for a victim or survivor, it may be they need a lot more resources. They may need more specialized therapy that is outside of your scope of practice, that is to address the trauma. So it might need an additional referral. Or if the person is the perpetrator, really looking at, is this a scenario if they've been repeating the cycle of abuse that they experienced in past relationships or as a child? Do they understand what healthy relationships and healthy communication is? And kind of helping them to work through that. And again, it may get to a level with any of those types of scenarios where it is outside your scope of practice, and that's okay. Helping a patient to identify those resources and where they can get that proper help is one of our responsibilities in providing referrals and resources. And addressing the trauma, you know, whether it's the past or current abuse, including the safety planning. So it was mentioned earlier that, you know, making a report almost too soon could be even more dangerous, or without their knowledge could be dangerous. And absolutely. So thinking about safety planning, it's not just this mandatory reporting or permissive reporting. It's what other steps do I need to help this patient with possibly. They're willing to make the report, but if we do it right now, they have nowhere to go, they have no money, they have no family, and the situation could have just gotten much worse. So being able to do that safety planning with them and walk them through that. For your own self-care, I think it can be a struggle emotionally and ethically to try to tease apart mandatory reporting from permissive reporting, and even weighing that against your personal values and beliefs and ethics. And that's why it's so important to rely on your professional peers as appropriate. Use your supervisor for guidance and support. Take advantage of EAP services if you need to. This type of thing absolutely can cause secondary trauma or compassion fatigue and impact your own self-care. And it's okay if you feel like, you know, there's a limitation that you have with being able to address these things and it's outside of your scope of practice. That doesn't mean that you're a bad counselor, that you don't know what you're doing. Everybody has a scope of practice they're comfortable and feel knowledgeable working in. And then boundaries, you know, keeping that in check for yourself, explaining that to patients, countertransference if somebody has had their own situation happen in the past, and or even not, if you know somebody that it's happened to, and it can be a struggle to not want to kind of protect this patient and do everything you can for them, but you need to keep that within the appropriate clinical boundaries within your professional settings and professional ethics. Sorry about that. Reminder for steps for reporting. We've talked about all of these, but making sure, you know, it's not just talking with your supervisor. This is the type of thing where it's really important to do your documentation as soon as possible, because those records could get requested and may be needed in some sort of a case, maybe something that is beneficial to the patient, or something that is important to be able to document and may have to be released depending on what the outcome is of the report. And so the more detailed and your memory being really good about what exactly happened or what you did, really important to do that documentation thoroughly and as quickly as you possibly can. And to make sure we don't miss any steps, not just for general compliance, but just for everybody's safety, for your peace of mind in knowing that you checked all the boxes, is to double check with your supervisor and the program sponsor about, okay, did we take all the steps? Did we do everything we were supposed to? Anything left for us to do? And then, as we stressed multiple times, being mindful of your state's reporting laws and requirements, because just because you were familiar with them 5 years ago, if they've recently changed, you might need to review that and give yourself a refresher. So going through the post-test, the same questions we had at the beginning. So the first question was, HIPAA and 42 CFR Part 2 prevent me from making any type of report of abuse of a child or vulnerable adult. That is false. It doesn't prevent you from making the report. You just have specific guidelines on what information you may be allowed to disclose or not. Number 2, I should never tell a patient that I made a report or involve them in the process of making the report. That's false. As we discussed, very often if you can involve them, that's a better thing, and it's a case-by-case basis on whether or not it's appropriate. Number 3, examples of elder abuse or abuse of a vulnerable adult includes things like hitting, neglecting medical needs, physical restraint, and misuse of their finances. That's true. Federal laws do not prohibit me from duty to warn as long as I only disclose the information that is absolutely necessary and that is specific to the threat or danger. And as we just discussed with Tarasoff and the case example that Christine provided us, that is absolutely true. You can make that report as long as you stay within the guidelines of confidentiality as required. Number 5, counselors should only report child abuse if they directly witness themselves or can provide proof of their claim of the abuse, and that's false. Depending on your state, that could include reasonable suspicion or secondary report. Number 6, prior to making any report of abuse or duty to warn notifications, I should always first speak with my supervisor to ensure I am compliant with correct procedures and laws. True. Number 7, feeling conflicted about having to make a mandatory report or upset after witnessing a reportable event means I am not a competent counselor. That's absolutely false, as we just talked about. And number 8, how I clinically address a patient's disclosure and their behaviors that led to the reporting can be affected by different factors such as whether the patient was a victim or perpetrator and whether the abuse is still occurring. And that is true. So that is the full session. Does anybody have any final questions or comments? Okay, so if you don't have any additional questions, I just want to give you guys a quick reminder to make sure that you complete your training evaluations, so those can be sent to Christine for your CEUs, but also if the managers at the different locations, if you could make sure for the sign-in to actually, when you send that to Christine, if you could please actually fill in the Excel sheet that she sent out for the attendance sheet and fill in all of the staff's names who attended, because sometimes with the written, it can be difficult to make sure we've got the name correct, and so it's printed correctly on the certificates. All right, thanks so much, guys. Have a great rest of the week.